Straight ahead on Law and Crime Daily. A New York judge orders Donald Trump and his kids to appear for depositions, the latest in the New York Attorney General's investigation. Plus, one-time doctor accused of murdering dozens of patients. We take a closer look into the case of William Husel. And the movie theater murder trial. Will ex-police Captain Curtis Reeves take the stand in his own defense? But first, the sentencing of Kim Potter.
A police officer who was supposed to serve and protect took so much away from us. She took our baby boy with a single gunshot through his heart. She shattered mine.
How long the ex-officer will spend behind bars for the death of Daunte Wright. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer, along with Terry Austin. Months after she is found guilty in the death of Daunte Wright, ex-Minnesota police officer Kim Potter is sentenced to 2 years in prison. Per Minnesota sentencing guidelines, Potter would serve only 16 months behind bars, and the rest under supervised probation. Judge Regina Chu addressed the shortened sentence length and got emotional when reading a statement.
I recognize there will be those who disagree with the sentence. That I granted a significant downward departure does not in any way diminish Daunte Wright's life. His life mattered. Officer Potter made a mistake that ended tragically. She never intended to hurt anyone. Her conduct cries out for a sentence significantly below the guidelines.
Potter was found guilty of first and second-degree manslaughter last December in the death of 22-year-old Daunte Wright. In April 2021, Wright was pulled over for unregistered vehicle tags. Officers later attempted to take him into custody when they discovered a warrant was out for his arrest. Potter shot and killed Wright. She maintains she accidentally grabbed her gun instead of her taser. Before a sentence was handed down, victim impact statements were read to the court, most notably an emotional speech given by Wright's mother.
Your Honor, I hope the defendant is listening as I speak loud and clear today. And yes, I refer to her as defendant because I will not give her the respect of calling her by her name. She referred to Daunte over and over again as the driver, as if killing him wasn't enough to dehumanize him. She never once said his name. And for that, I'll never be able to forgive you. Daunte's smile was genuine and big, just like his dreams. You took this. You took his future, what he could have been, and it was so many things. April 11th was the worst day of my life. A police officer who was supposed to serve and protect took so much away from us. She took our baby boy with a single gunshot through his heart. She shattered mine. My life and my world will never, ever be the same.
Kim Potter also addressed the court and Wright's family, sobbing as she gave an apology.
To the family of Daunte Wright, I am so sorry that I brought the death of your son, father, brother, uncle, grandson, nephew, and the rest of your family to your home. Katie, I understand a mother's love, and I am sorry I broke your heart. My heart is broken for all of you. Earlier, when you said that I didn't look at you during the trial, I don't believe I had a right to. I didn't even have a right to be in the same room with you. I am so sorry that I hurt you so badly. My heart is broken and devastated for all of you.
Joining us today is criminal defense attorney Bernardo Villalona and Terry Austin. Bernardo, just 24 months. Is this the right sentence? And what do you think of the defense's arguments for a lower sentence?
It's definitely not the right sentence, but regardless what the sentence could have been or would have been, nothing will bring back the life of Daunte Wright, and no sentence will signify the worth of Daunte Wright. I'm disappointed with the sentence, but let me just tell you how did we get here in regards to the defendant and the defense's argument to the judge. As we know, there are sentencing guidelines. There's nothing that is mandatory about the sentence. In terms of the arguments that were made, the defense attorney made it a point to say that 65% of the time when it goes to sentencing women, the guidelines are not followed. But aside from that, one point that he made that I was really disappointed by and offended by is that he made Daunte Wright to be the person that because he was under the influence of marijuana, because he had an open warrant, because he was driving with a suspended registration sticker, that he caused this upon himself, and argued to the judge that those are mitigating factors and why former police officer Kim Potter should be sentenced to probation. I'm insulted by that, but hey.
Yeah. Now, Terry, whose victim impact statement do you think affected the judge's decision the most?
Absolutely none of those statements affected the judge. I believe she had her mind made up before she walked into that courtroom. You could tell, obviously, she was reading from a prepared statement. What I will say is she was persuaded by the briefs, and she looked at the state's brief and basically said, you have not proven any aggravating circumstances so that she could exceed the guidelines. She said that the defendant did not cause greater damage or danger to others and that Kim didn't abuse her authority. Obviously, I think others would disagree with that. And she listened to the defense arguments. She said it was a sad case and she leaned on the side of Kim Potter. So definitely she was favoring the defense there.
Yeah, one thing I'd be interested in, she looked at a lot of letters that were sent to her. I would hope that those would make it into the court file, so maybe publicly we can see what letters she relied on in coming to this sentence because it was so significantly lower. Thank you both. Still ahead on Law and Crime Daily, William Husel is set to stand trial next week. Everything you need to know ahead of the opening statements. But first, the defense calls its first witness in the murder trial of ex-cop Curtis Reeves. Our legal analysts break down the case so far after this.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. The defense began calling witnesses Friday morning in the Florida case of retired police captain Curtis Reeves. Reeves is on trial for killing fellow moviegoer Chad Olson inside a theater in 2014. Reeves and Olson got into an argument over Olson being on his cell phone during movie previews. Some witnesses testified to Olson throwing popcorn before the shooting. Reeves says Olson threw his cell phone at him, saying he shot Olson in self-defense. Testimony began Friday with a detective from the Pasco County Sheriff's Office. He was asked about his interview tactics after the shooting happened, including why he didn't use recorders when interviewing witnesses. He was also asked about his experience with investigating homicides, as a defense attorney questioned his lack of time spent training in that division. The topic of questioning once again turned to the cell phone and talk of whether it had Reeves's DNA on it.
You had a conversation, did you not, with the crime scene forensic tech, whatever you want to call it, concerning that phone that was on the ground. You had a conversation because she asked you, hey, what do you want me to do with this phone? Hey, what do you want me to do with this phone? You want me to turn it off? She picked up that phone from the floor with gloves on.
Yes, sir.
And started manipulating the phone to turn it off.
There, you have to manipulate the buttons on the phone to get it to turn off. Yes, sir.
Because you didn't know that that phone was possibly used to strike Mr. Reeves in the head.
I was not aware that that accusation had been made.
Because you know if someone is manipulating a phone, that possibly the DNA that is so critical in a case may go away on your glove.
It's possible it could get wiped off.
Reeves' son and daughter took the stand Friday afternoon. We'll hear from them next on the next episode of Law and Crime Daily. Let's bring back criminal defense attorney Bernardo Villalona and Terry Austin to discuss the defense of Curtis Reeves. Terry, what did you think of the defense's opening witnesses? Did they start off strong, and is there any reasonable doubt yet?
Well, I think they had a decent start. I will say this defense attorney attacks everyone. He has a certain style about himself, and it makes you wonder, does he believe anybody anytime? It's just antics. But I think having Detective Aaron Smith on the stand and talking about the tactics, it's something that we see done a lot by defense attorneys. They try to say the investigation wasn't done well, and perhaps it wasn't. But this whole phone incident, I think, is a red flag. It really didn't matter whether or not the DNA was on the phone, because we know that the phone belonged to Olson, and we know that the phone was in his hand. So I think he's making a big deal about an issue that really isn't an issue. We also know who the person was who shot. So I think basically, that it was just a red herring there.
Yeah, he's trying to make something out of it. I'm not sure how much he will win on that one. Bernardo, do you think Reeves will take the stand? And if so, what do you expect him to say?
At this point, I don't think there'll be a need for Curtis Reeves to take the stand. Usually, when you're trying self-defense cases, you have to put your client on the stand to be able to explain to the jury what was going through their mind for them to believe that there was a need to use deadly force. However, in this case, the prosecution put in Mr. Reeves' his statements, his admissions to the police. So there's nothing more that he could add in the sense that I think will help him out in this case. But who knows? We'll see what happens.
Yeah, and if he doesn't take the stand, he doesn't get cross-examined. So maybe that statement through the interrogation is the best one he's got. I agree with you. I hope we see him on the stand, but might not happen. Well, coming up on Law and Crime Daily, possible depositions ahead for former President Donald Trump and 2 of his adult children. Plus, a one-time doctor accused of murdering dozens of patients. What you need to know in the case of William Husel. Next. Welcome back to Law and Crime Daily. Was he committing murder or just doing his job? That's what an Ohio jury will have to decide in the upcoming trial of William Husel, a doctor accused of killing patients after administering excessive amounts of painkillers. We spoke with Hussel's attorney, a lawyer who has worked on some high-profile cases in his career, and he says he's not going down without a fight. Here's Law and Crime Sierra Gillespie with more.
If this prosecution team wants to convict Dr. William Husel, they're in for the fight of their life.
Attorney Jose Baez is representing intensive care unit Dr. William Husel as he faces trial for the murders of more than a dozen people who are being treated in the ICU. The deaths occurred between September 2014 and November 2018 at Mount Carmel West and Mount Carmel St. Anne's hospitals in Columbus, Ohio. Over 2.5 years, 35 patients under Hussel's care died. Prosecutors say the vast majority were given excessive amounts of fentanyl, a synthetic opioid which is stronger than morphine.
Detectives reviewed approximately 30,000 pages of documents, consulted with medical professionals, and conducted numerous interviews with witnesses and family members of the deceased. The investigation revealed probable cause linking 25 deaths that were a direct result of the known therapeutic doses of drugs, including fentanyl, that Dr. William Scott Husel ordered to be administered in excess of medical standards.
In 2019, a grand jury indicted the 46-year-old with 25 counts of murder. In January, prosecutors dropped 11 of those counts, establishing a threshold of how much fentanyl was given. Hussel's defense argued he was doing his job providing comfort care to patients who were in pain at the end of their lives.
There's something that needs to be known. There was no policy precluding these doses, number one. So the hospital had no limits on what Dr. Hussel could prescribe, and he prescribed what he felt was in the best interest of the patient and their families.
Baez was launched into the spotlight after a Florida jury acquitted his former client, a name you may recognize, Casey Anthony. It's not unusual for doctors to lose patients. That's just part of being a doctor. But the families of Hussel's patients thought there was something more going on. In October 2018, the formal reports of concern started coming in. By November, the death of Melissa Penix is believed to have prompted the hospital to start investigating Hussel. Then, by early December, Hussel was fired, along with at least 20 nurses and other hospital personnel who were placed on administrative leave pending the investigation. June 5, 2019, Franklin County Prosecutor at the time, Ron O'Brien, announced Hussel would be charged with 25 counts of murder. That same day, the former doctor surrendered to Columbus police. And just 2 days later, he made bail. A judge set Hussel's trial date to start in May 2020. Then the COVID-19 pandemic hit, prompting several delays. William Husel will now finally face a jury.
It is our sincere hope the families of these victims will find solace by the state of Ohio holding Dr. Hussel accountable for his devious conduct.
For Law&Crime Daily, I'm Sierra Gillespie.
If convicted, each of the 14 counts of murder Hussel is charged with carries a mandatory sentence of 15 years to life in prison. Opening statements are set to begin on Tuesday. Criminal defense attorney Bernardo Villalona and co-host Terry Austin are back to break down the trial of William Husel. Terry, what would you say to the argument that this is a civil matter and not a criminal one?
Well, you know, Brian, I think it's civil and criminal. Obviously, it's ripe for criminal charges. He's being charged. We'll see if there's enough evidence to say that he was intentionally killing people. But an argument really can be made, and there are civil charges already brought, that he was negligent or reckless, and that the hospital should be responsible and paying for this, and that he should have some compensatory damages charged against him because the victims' families suffered as far as this was concerned. But, you know, we've seen some of the nurses actually in that civil case testify that this comfort care near the end of life is something that you commonly see. And I know for a fact it happened with my mother when she was passing. So I think for a fact that, you know, there are two arguments to this, and you have to determine based on the evidence whether or not he's liable.
Yeah, Bernardo, speaking of different arguments, I'm kind of looking at this from a defense standpoint. Do you believe the defense can win based on a missing element of a crime, or a jury who simply believes the doctor was being compassionate to his clients?
This is going to be a difficult case because, number one, you're dealing with 12 jurors. So you're going to have to get a unanimous decision regardless of what the verdict's going to be. So even if you try to go for jury nullification, meaning that the prosecution proved their case beyond a reasonable doubt, but you want, as a defense attorney, for the jury to set that aside and for other reasons, whether it's compassion or feeling bad even for those that passed away because they were coming to their end and he was just trying to provide comfort, and say, you know what, you're not guilty, but you need 12 jurors to be able to reach that conclusion. It's going to be a difficult case. I'm not sure what the defense is going to go with here, but there are strength in numbers, and you're talking about all these people that died in your hands.
Yeah, and I mean patients, not clients. Obviously, I'm a lawyer, not a doctor. But when we come back, the latest in the New York Attorney General investigation into the finances of former President Donald Trump. Will Trump and his adult children face depositions? The latest after the break. Welcome back. Now looking at news out of New York. A judge has ordered former President Donald Trump, Don Jr., and Ivanka to answer questions under oath about the Trump Organization's business practices. All three have been subpoenaed by New York Attorney General Letitia James. She says it's an effort to uncover the truth about the company's finances. The Trumps have fought back, claiming James is politically motivated, but New York County Supreme Court Justice Arthur Engron ordered for the three to be deposed within the next 3 weeks, as well as submit any documents that have been subpoenaed. James is inquiring about several statements of financial conditions which have been inflated by millions of dollars. The Trumps would be able to plead the fifth. So far, they have denied having information affirming the allegations. Bernardo, the judge has ruled they'll be deposed, but as I said, even if they do testify, they'll likely plead the fifth. So where do we go from there?
Well, that's the first step that the AG wants to do, is that they want to get at least the Trumps on record saying that they're going to plead the fifth or they have nothing to say. They want to get an answer from them. So that's the first step. But how do we build a case? How is the AG going to be able to build a case? And don't forget that there is still a case in New York County, not directly having to deal with Donald Trump, but something having to deal with his organization. Regardless, I'm hoping that at least at the conclusion of this, even if there are no charges, that the AG releases a report, just like how she did for former Governor Andrew Cuomo.
Yeah, we saw a lot in that, as you're saying, the Andrew Cuomo case, and that's part of my question with Terry. If the family is deposed, will the public get to see it, or will this be sealed for years?
Well, you know, there's a great argument that the public should be able to see it. We need transparency here. And all of these individuals are private citizens. There's no reason that it shouldn't be public. He's not claiming executive privilege. We know that. He's got to testify. There is a probe of his business practices, and there is a real good argument that we should be able to not only listen to what they have to say, but see all of these documents. The accountants released all of these records, decades worth of records about his finances. Trump has said in the past that he knows all about his finances, that he can talk about his finances. So we're hoping that that is public. We can see it. We can learn that information. And frankly, if he does, and Ivana and Donald, if they all plead the fifth, then we'll know in a civil case that can be used against them, unlike in a criminal case where it can't.
Right. Either there's where there's smoke, there's fire, or this is a witch hunt. Either way, accountability and some be able to see these records will help. Well, thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.